Excuse me.
You haven't given us the reason though why either Article 3 courts are insufficient or courts-martial, if necessary, to handle some of these cases. Now, in particular, the Article 3, the notion, and what I heard, was kind of a cost-benefit. If we need to, in fact, appoint more judges or provide more resources, Congress can do that very easily without offending the Constitution. I would just note that it isn't just the provision on confrontation that you're talking about offending. You're also talking about the right to a jury trial.
Right.
And so you are looking to upend some of our basic requirements in the Constitution.
I was the first one to say that. I was the first one to say, Mike, that there are constitutional problems with the proposal. That being said, I think there are more profound constitutional problems with where we are today.
Why not Article 3 court-martial?
Because court-martials, as I understand court-martials, and Dave Graham can correct me if I'm wrong, court-martials are for the purpose of bringing soldiers to trial, American soldiers. These are American soldiers. And my other argument would be that Article 3 courts, again, in the context of jury trials and the thousands of people who need to be brought to trial, I would suggest, are ill-equipped, unequipped to go forward with that process. We have time for one more?
When I first heard you say this, I thought maybe I was misunderstanding, but you've answered a question that makes me think I'm not. And there are, profound issues, and you've raised them with the procedure that you're describing. But I'm concerned about what I think I hear you saying about the substance of these courts, the actual charges. Even the military commissions have not proposed to charge people for anything other than crimes which they have committed. Are you talking about a trial to determine whether someone is dangerous or not?
No.
So you're still talking about trying them
for crimes. All I'm saying is the only people who can be put into this category are those who are deemed to present a threat based on intelligence information. If they're not deemed to present a threat, then we have to, I think, would release them. Those who are deemed to present a threat would be brought to trial based on acts that they've done, not for the crime of a threat.
The other issue is that, don't you agree that because we haven't run Article 5 tribunals, that even if you did this, that would have to be done under international law as a prerequisite to doing this, to avoid violating their rights under Geneva?
Meaning to what?
Well, of course, if you have someone who's entitled to prisoner of war status, it's a crime to try them other than by courts-martial.
Right, but the other thing that also needs to be done, very frankly, is we need to, I think, begin the process of defining what are they. Are they POWs? Are they criminals? Or if they fall into what I call the hybrid, which lends itself to the articulation or proposal of a domestic terror court, because they fall into a hybrid which is neither here nor there. Thank you very much.